It's good to have you, Rick. Thank you for joining me on the Middleton Ford Hotline.
Well, thanks for having me on, Vicki.
So this is a suit brought by Tony Evers, to prevent this little committee. It's a very powerful little committee called the Joint Committee for the Review of Administrative Rules from blocking his rules. So, this committee is a legislative committee. And when the administration decides it wants to change a rule or it wants to impose a new rule, it has to go before this committee. And if this committee decides not to advance the rule, then the rule doesn't go forward. I mean, I'm simplifying it too much, I reckon, but that's kind of basically it. So essentially, Tony Evers is suing to take away legislative oversight from rules that act like laws. So where are we on this?
So, again, this is one of these cases where the thing that everybody focuses on, this is about a rule that, bans therapists from trying to get people to accept their biological gender, and, they call it conversion therapy. And this case is not about that. This case addresses a really fundamental problem. We all know that administrative agencies have become much more powerful, and they make a lot of the laws that we live under. And there's a problem with that because the legislature is the body that is supposed to make the laws. And so people struggle with, some way to restrict or draw a circle around the discretion of administrative agencies. Sometimes you want them to make rules. The legislature can't specify everything in the law it passes, but you don't want them to become mini legislators in which these uneducated bureaucrats make the laws that we wind up living under. So one of the ways this happened in Wisconsin is there are a series of procedural protections. There's a certain way that agencies have to make rules. And there's also provisions for legislative oversight, and that's what we're dealing with here. The legislature, which is the body that granted the agency the powers to make these rules, said at the same time we're giving you this power, we are retaining the power of oversight, and this is the way we're going to exercise it. It goes to this committee that we're going to have called the JCRAR, which consists of the members of both the Assembly and the Senate, and they're going to have the authority not to permanently block the rule, but to suspend it until such time as the whole legislature can decide whether the rule should go forward or not. Although they can do this, in series, they can do this a number of times, so it is a little bit more complicated. And
but that's okay. Yep.
So what Evers is arguing is, no, you can't do this. This is a violation of the separation of powers because the executive has the authority to make rules, and the only way that you can overrule that is if the whole legislature passes a law, right? Both the Senate and the House, and it gets signed into law by the governor. And so what the governor essentially wants here is he wants to have his cake and eat it too. He wants the legislature to authorize the agencies to make rules, but now is unwilling to live with the restrictions that the legislature has placed on that ability because he says that this violates some core executive function. And so the big legal debate here is rulemaking an executive or legislative power. And we've been pretty clear, and the legislature have argued here, and we submitted an amicus brief in a related case saying, look, this is a legislative power. Now, our preference would be that the legislature not do this at all or do it only in limited cases, and that's called the non-delegation doctrine. We don't have to get into that right now. But if they can't do that, then at least there should be some form of legislative oversight, and this is part of that process where the JCRAR can suspend the rule for the legislative review.
So it's not about conversion therapy. That's a dumb rule. That was, by the way, without science.
It is a dumb rule, but it's not. Yeah, but
it's not. That's not the problem. That's only in this case because it gets the left wing media's attention, and they turn it into some kind of attack on trans rights. Which, by the way, trans rights. Where's that Declaration of Trans Rights in the Constitution? So that's all that's about. It could be any rule. It could be a WEC rule. It could be a Department of Revenue rule. It could be a DNR rule.
There are other,
And we have agencies that shoot from the hip on rules, sometimes not even publishing rule changes that act like law. And here's Tony Evers saying, yeah, the legislature can't have any oversight on that. We should be able to essentially make law through the rulemaking process without any legislative oversight. That's, and that's insane. And Governor Walker, in his term, made it a reform that made it harder for an executive to do that, including him as an executive.
That's right. And, the alternate to Evers' position, if Evers doesn't want to have overview by the JCRAR, then our position at will would be, and we've suggested this in other cases, is that we have to bring back the non-delegation doctrine. If that's going to be the rule, then the legislature cannot delegate its authority to make major policy decisions to the administrative agencies at all. When we've made that argument in the past, the response we've gotten is, well, we have these procedural protections. We have rulemaking. We have the JCRAR. Well, now the governor wants to take that away. And all I can say to Governor Evers is be careful what you wish for, because if we can't have oversight this way, then maybe we don't have this delegation of authority to the administrative agencies at all, which I personally would be fine with.
So he's basically saying, and I'm with you on that, by the way, the legislature should do its job and not offload responsibility for the implementation of the laws it passes to a bunch of unelected bureaucrats who then want to abuse that authority. Period. That's just, it's a terrible idea. And I know it creates more work. And, I don't really think they earn their keep in the first place. So I think that extra work, or you hire additional staff, but the legislature ought to be the one who decides what the law means and how the law is implemented. But here's Tony Evers essentially saying that if I make a rule through my executive agencies, and let's say it's a DNR rule that says, you have to have X amount of, I don't know what it is, or X amount less impervious surface for every square foot you add onto your building, right? Something like that. And he just shoots from the hip and decides to do it because a bunch of environmentalists decided they wanted him to do it. Then the legislature has to negatively, go into session to undo what functions as a law, right? And why would our legislature, be a body that has to spend time undoing executive actions when it's the legislature we elect to create the laws in the first place? We don't elect Tony Evers or any governor to create laws. They are executives. They're supposed to manage the state. So why would you want to put it in reverse like that?
No, I don't think you do. I mean, I think you put it well. I think the legislature has to do its job. And we have this issue on the federal level too, where
Yes.
in connection with the Chevron doctrine or attempts to revitalize the non-delegation doctrine in federal courts, one of the things the Supreme Court has said is, look, the legislature does hide, mountains inside of mouse holes. And nobody in the legislature, nobody in the state of Wisconsin ever voted on the issue as to whether or not a code of ethics for therapists should ban them for trying to convince people to accept the gender that they were born with.
Right.
And so the idea that this is something that these unelected bureaucrats should be able to do without legislative oversight, I don't think they should be able to do it at all. But to argue that they should be able to do it without legislative oversight is a real usurpation of legislative power and a real enhancement of executive authority. And here's the irony. So today, President Trump is going to be inaugurated, and he's going to sign a bunch of executive orders. And, I'm sure that many of them will be just fine, and they'll be great, and he'll have the authority to do it. But it could be, don't know, but it could be that some of them will exceed his power. He may get too aggressive on these things, and the people on the left will run around in the streets screaming about, dictatorship and, how the president is trying to turn himself into a king. Well, at the same time, they've taken these positions when they're the ones that have executive authority. And I think that we all should be more concerned about doing things right and respecting our separation of powers. And Governor Evers is not doing that here.
No. And how about you respect the people? Because when you do this and you usurp the will of the people as expressed through their legislators, then you are flipping the bird at the people, period. That's what you're doing. Again, we didn't elect Tony Evers to make laws. We elected a legislature to make laws. And with regard to this one, specific rule we're talking about here, who is responsible? Who can we fire if we don't like the rule? How do you undo the rule? That's the question. How would these therapists, which, by the way, the rule would have the force of law, they could lose their licenses. Many other types of penalties could be, visited upon them. Where do they go to object? Their legislators? Yeah, they don't. You complain to a board. The board says, sorry. Here's my last question for you. The liberals on the Wisconsin Supreme Court have already telegraphed their thoughts on this. Oral arguments were last week. I'm not optimistic here, Rick.
Well, I wish I could disagree with you, but I think that I once again, I think our friends on the progressive left, they should be careful what they wish for, because there will be a governor they don't like someday. There will be a president they don't like someday, and what they're saying here is, and I think you put this well, that they're reversing the direction in which our Constitution says decisions should be made. They're saying, well, the executive can do this stuff unless the legislature, then the whole legislature overrides them, and they agree to be overridden or the veto is overridden. And that's got it exactly backwards. If we're going to have a conversion therapy ban, the legislature should be the one to pass it.
Thank you for joining me on the program today. I appreciate it. Rick Esenberg from the Wisconsin Institute for Law and Liberty, will-law.org if you'd like more information on the Wisconsin Institute for Law and Liberty.